Good afternoon, this is Sean Golding with Golding & Golding, here to discuss the basics of the voluntary disclosure opt-out procedure. Does it still exist? Can you use it? How does it work? And why would you need it? So the idea behind voluntary disclosure is that if you were willful, these days at least, and we'll get into that, but if you're willful or just can't certify under penalty of perjury that you're non-willful, you don't qualify for things such as streamlined delinquency procedures, reasonable cause, and you're left with the voluntary disclosure option. The idea behind voluntary disclosure is you get hit with a pretty hefty penalty, but as a result, you sidestep or circumvent any criminal investigation. The IRS doesn't absolutely guarantee it, but for the most part, we've been doing this for a long time. We've never had someone enter the voluntary disclosure program and then get criminally indicted or investigated for anything that was submitted as part of the program. Okay, if someone does something criminal down the line, we're just doing a voluntary disclosure is not going to guarantee against any issue ever. But for the most part, as long as you make a full and complete disclosure, you'll be fine. You don't get hit with an indictment or criminal complaint. Okay. With voluntary disclosure, these days you're considered willful, right? You wouldn't enter the current version of the voluntary disclosure program if you were non-willful. Okay. By doing voluntary disclosure, you typically will have to pay a 50% penalty. Okay, and we're focused this on the offshore aspect of it, right? Voluntary disclosure these days, since they got rid of OVDP, which was an offshoot of the Offshore Voluntary Disclosure Program, an offshoot of VDP, they got rid of that, and so now VDP was enhanced, and it includes both domestic and offshore. Under the current version of the program, it goes by the Internal Revenue Manual, okay? So typically, you're presumed willful under the program. You pay a 50% penalty. You look at a 6-year compliance period. It used to be 8 under OVDP, now it's 6. Okay. You go back 6 years, you figure out the highest maximum balance of unreported accounts for those years. You pick the 1 year that's the highest, you get hit with a 50% penalty or $100,000, whatever's higher, which typically means that's the floor. Okay, and it goes by the Internal Revenue Manual and the code, and that's what the agents base it on. So under the prior version of the program, it was OVDP. It was a 27.5% penalty unless you were at a bad bank. There's a list, I think it's 145 bad banks. If you had any of your money in that bank, then all of your penalty was subject to 50% instead of 27.5%. Here's where we get into a little bit of the boring history, okay? Under OVDP, that program came around, I think it was 08 or 09, it used to be OVDI. It was for people who were willful or non-willful because the streamlined program that is popular today, the standalone version of it, didn't come around until 2014 mid-year. So if you submitted under OVDP and you're non-willful, well, it was absurd to pay a penalty. The penalty wasn't as high in the early version of the program, but it kept increasing, okay? So in order to offset that, the IRS developed the opt-out program. With opt-out, you remain in OVDP, so you still get the criminal protection. But as to the penalty, you can kind of roll the dice. And it was a very complicated, detailed analysis. Depending on the agent you received, oftentimes the penalty could actually be worse. I mean, we never had that situation, but it does happen. You weren't guaranteed a lower penalty. You were guaranteed the opportunity to try to get a lower penalty. So the problem these days under the new VDP is some practitioners are taking the strategy of just scaremongering potential applicants who are clearly non-willful into VDP with the idea that you get criminal protection, and aside from criminal protection, you get 6 years of compliance instead of 3, and then down the line, the attorney or practitioner will try to get that penalty negotiated down to the non-willful. It doesn't work that way under the new version of the program. There's no formal opt-out. Under the new version of the program, essentially, everyone is audited who enters the program. Now, that doesn't mean that it's some big drawn out audit with 20 agents hovering around you asking you, a barrage of questions one after the next, but everyone basically has to go through an audit. They typically last 60 to 180 minutes. typically done by telephone. It's part of the procedure. So what's important is if you get hit with that penalty, it's not like then you can just opt out in the same way that you can opt out under the prior version of OVDP. It was a formalized process. Under the new version, okay, you can try to dispute the penalty. The chance of the IRS waiving that penalty or reducing it is pretty much slim to none once it's been issued. Typically, once it's been issued, what would happen is you would have to pay it and sue for refund, or you have to wait till the IRS goes to enforce it and then dispute it. But you know what? If that happens and you're in court, then especially with things like reckless disregard, which a lower level of willfulness, and they can still go after the willful penalty, most likely what's going to happen is the court's just going to say something like, hey, well, you entered the voluntary disclosure program. You could have done streamline. You could have done reasonable cause. You could have done delinquency. Chances are they're not going to reduce the penalty. So the point is, if you were non-willful, be very, very cautious about entering into voluntary disclosure. You probably don't need any criminal protection. Typically, the statute is 3 years, okay? Not 6 years, except in certain situations, but it's typically 3 years. And if you're non-willful doing voluntary disclosure with the idea that you may get the penalty removed down the line or get it reduced is probably not the best strategy, okay? We have lots of information available on our website, goldinglawyers.com. We've got some sub-websites that identify specific targeted international tax issues to assist you. You can always reach out and schedule a reduced fee initial consultation if you think it's appropriate. Again, my name is Sean Golding with Golding & Golding. Thank you for your time. Enjoy the rest of your day.